Okay. Welcome everyone. Welcome our participants to the 12th Junior Faculty Forum Paper Workshop. Thank you, Jeff and Anumeha, to agree as your roles as discussants. Thank you, Karan and Tushar, for sharing your paper to be discussed. So before we dive into the workshop, I'll mention a few things about the Junior Faculty Forum and about housekeeping. We have Professor Tarunabh Khaitan, who will not be joining us today from Oxford University, Dr. Dinesha Samraratne from University of Colombo, Swati Javeri from NUS Singapore, and Professor T.T. Arvind from University of York as Fantastic Advisory Board. Along with them, we have Dr. Animesh Das Tavini from University of Colombo, and I from Dharmashastra National Law University as the conveners who do the background work. And the whole idea of having junior faculty forum is discussing the draft papers written by South Asian scholars or written on any of the aspect of South Asia, and having a constructive discussion so that the authors can improve upon their draft papers. So we'll start the workshop. I'll just mention two more things. Unless you're speaking, I would request you to keep yourselves mute. Cameras can be switched off by those who are not speaking so that it does not disrupt who's speaking. We'll record this session and put it on our official YouTube channel. And we start with comments from our wonderful discussants today. Jeff Redding, who's Senior Research Fellow from University of Melbourne. Welcome, Jeff. And Anumeha Mishra, who's Assistant Professor in University of Delhi. So we'll have comments from our discussants, Anumeha, followed by Jeff. And then our wonderful authors, Karan and Tushar, can choose to respond to any of the comments or all. It's not mandatory to respond all the comments to all the comments. And thank you, Karan and Tushar, for a wonderful paper. The paper is on inheritance rights of transgender peoples in India. The topic is new, and I have not read much on inheritance right of transgender people in India. Not much research I can see is done on the topic. And so we should, I think, start with comments from our discussants. Anumeha.
Thank you, Swati. I hope I'm audible to everyone.
Yes.
Thanks. Good morning, everyone. At the onset, I would first like to thank JFF for inviting me to participate in this workshop. I think as a discussant, it has been a learning experience for me reading the paper. Now, Karan and Tushar have shared a wonderful and I think a contemporarily relevant work on inheritance rights of transgender persons in India. And as Swati also mentioned, we hardly find such works in the literature, and that is perhaps one of the reasons that, and because I am teaching, and I've also been teaching family law at Delhi University, we do not discuss those issues even as a part of the syllabus, perhaps also because of the lack of research in that area. So that's why I would first like to congratulate both of you for picking this topic. The best part that I liked about this work was that the draft which has been shared with us is informative and also very well articulated. The language and the presentation makes it easily comprehensible to the reader. Generally, many times when we read academic writing, we come across dense construction of sentences. But the excellent part about this paper is that it's very easy to comprehend. So it engages the reader. We don't lose track between mid-sentences. The structuring of the article is also very pleasant also to look at with the tabulations and some of the arguments which have been given by way of tabulation. I think that helped a lot. So I really found the information that we have collected about how many gendered pronouns have been used in the various codified laws to be excellent. It was really appealing to me in your paper. Now, coming to the paper and the content, I have 3 to for main comments that I would like to make and respond to the paper. Now, if I understand correctly, and Karan and Tushar, you might correct me if I'm wrong, the paper cites gendered law and gendered identification as two most important reasons for the lack of, let's say, lack or inefficacy of the legal framework supporting inheritance rights of transgenders. So that's what I could gauge from the paper. Now, the good thing about this paper is that throughout the draft, we find a reference back to these two reasons. So it's there in the right in the very beginning where it has been explained, and towards the end also we find a reference to gendered law and gendered identification, and both of them have been discussed. So it's not that both of you have mentioned it and then went astray and started discussing something else. I think you have tried to revolve your arguments around gendered law and gendered identification. But what I thought was that perhaps it would have been possible, if it's possible, to conceptualize these two concepts more in the paper. And deal with it more rigorously and more critically. Now, in this authorities that have been cited, I do find a lot of critical literature which have been cited. And though I was not able to go through all of them, I tried to go through some of them. And I found that the literature that you have cited does deal with this idea critically. But while the paper does try to touch upon those concepts and conceptualize it, perhaps it could be more rigorously conceptualized. I think it would really add to the strength of the paper. So I'll just cite an example, if that may help. So the paper, if I may say so, supports self-determination and rather self-identification as best way to identify one's gender. But also in, like, not expressly, but in certain parts, it does recognize the fact that gender identification is a twofold process. One is self-identification, and the other is the legal identification. And it is not necessary that there is an essential connect between the two. Rather, what I found through the course of the argument was that the problem that both of you are trying to sort of emphasize on is that the self-identification and the manner the law identifies transgender is something which has a very big disconnect. Now, in that context, perhaps that disconnect could have been emphasized more. Some of the literature that you have cited does, for example, talk about the manner in which law has defined transgender, how that is problematic. So the authorities that have been cited in the footnote do touch upon those aspects, but that discussion is not very apparent in the paper. And as a reader, and this is a thought that came to my mind, I felt that because the first thing is, when we're talking about inheritance rights of transgenders, we need to first understand how is it that the paper understands transgender. So there are instances of that discussion, but if just coming back to my first, how I started with that, if you could conceptualize it more, I think that would really add to the potential of the paper and the work that you have done, the wonderful work that you have done. So maybe critically engage more with legal definition of transgender in India and use the research that you have already cited in the footnotes to and bring those ideas and your response to those ideas. How would you like to? How do you think transgenders and whether the definition is sufficient enough or not, and what is your response to those critical literature that you have cited? Maybe it would help more. Now, the second thing that may be developed further in this paper is the analysis of the law. Now, when I look at the abstract, I saw that it mentions that this paper analyzes legal framework for inheritance, and the SCC and Manupatra decisions have been referred to since 1950 to see how the term transgenders how the inheritance right of transgenders have been looked upon by the judicial decision. Now, the paper has adequately dealt with the judicial decision. Also, and I think this is one of the interesting part of this research, that we do not actually come across. We find all these decisions at one place. So that would be a very good reference this paper would be a very good reference source for anyone who would like to research on this topic. And it's very well updated. So that's the good part. But what I found was that the codified and the uncodified laws, while they have been discussed, they have not been discussed as much as they could have been. So we find references to Section 8 and 15 of the Hindu Succession Act. We find references to Indian Succession Act, and we also find use of these statutes, codified laws, when you are making the argument of how gendered and heteronormative the entire inheritance law structure in India is. But when you are analyzing those laws have not been analyzed, I felt, in as much detail as would have been possible. So, for example, and specifically what is lacking is, while there is a reference to Indian Succession Act and Hindu Succession Act, the Muslim personal law is comparatively less discussed as compared to the other two laws. And I think because those two laws are codified and the Muslim personal law is still uncodified in India. So that is also, I think, one of the reasons, and there is a lot of juristic differences in the Muslim law itself. So maybe that was one of the reasons or not. But if the paper could also have dealt with it, I think otherwise it does not look like a comprehensive analysis, but just a reference to Muslim personal law, while at the same time you are dealing, if not in extreme detail, which I realize in your conclusion that is not your intention to do so, but you are still dealing substantially with Hindu Succession Act and Indian Succession Act, but not with the Muslim personal law. So maybe that would also help, perhaps, to add to the paper. And the third point I would like to make is, and this is something that caught my attention, and I would rather, the sentence caught my attention actually, and I would quote it from your paper. It says, though this paper focuses on transgender rights, these challenges may affect women and other gender minorities, which I also completely agree with. However, I was just wondering what was the reason for having this sentence in the paper, because the paper does not actually engages much with this aspect, and it's an important argument. It's not just a factual statement that you are making or a piece of information that is there in the paper, but rather it's a claim or an argument that is being put in the paper. And I was just wondering if what was the idea behind putting this argument? It would clarify, or and why, and was it intention of the paper to engage with this specific idea of what are the challenges? Because, and the reason why I am raising this is because, and this is just me thinking aloud, it might or might not be relevant to your paper, that can we actually use this approach to, or this argument to approach the inheritance laws in India? Because what we have found is that what you make, the argument that both of you have made in the conclusion is that you do not need an overhaul of the legislation. Incremental changes are something that seems to be what you are concluding with. And this is just a question that I'm posing to you, because what we have seen is that incremental changes haven't helped much. And there's just one example of Hindu Succession Act, where daughters have been made co-partners post 2005 under Section 6. But despite that fact, it's not that daughters have got equal right as co-partners as well, because if you look at Section 6, when a male co-partner dies, there is a notional partition, but when a female co-partner dies, there is not. And this is something that you are focused on in your paper also, the discriminatory inheritance law for male and female in the Hindu Succession Act. Again, for a Hindu married woman, even if she gets herself registered under the Hindu Marriage Act, she is still governed by the Hindu Succession Act. So she does not have the option of being governed by the gender neutral law of Hindu Succession Act. So what we have found is that the only reason I'm giving this example is, and I understand your paper is not about it, is that we have found that incremental changes, do they actually help in addressing gender biases? And this is something where we are talking not just about removing the gender biases in the heteronormative structure, but rather demolishing the heteronormative structure altogether. So would you perhaps, would that help you if that this approach is taken, that, and the sentence, I think this sentence was something that invoked this thought in my mind, that is this the concern or is this the approach that you might like to take in addressing some of the analysis of the legal sections and provisions that you are doing? That's all for my side. I hope I have not exceeded my time. And again, I would like to thank Karan and Tushar for sharing their work. I think for me personally, it has been extremely informative. I'm definitely going to use these discussions because of your research. I'm much more well informed now than I was before I did paper courses. Thank you.
Okay, thank you, Anumeha, so for such wonderful comments. And I think the point that you mentioned in the last, it's with every JFF workshop, we read new papers and we get to know so many things. So that prima facie is the first very important basic thing that adds to our knowledge. Okay, thank you for wonderful comments, Anumeha. Can we have Jeff's comments? Jeff?
Yeah, so thank you so much for the invitation to comment on what I agree is a very interesting topic and an underexplored area in the literature, both in India, but in the broader South Asia region, and then perhaps even globally. So I think that the selection of this topic is to be commended. And I think you're hearing that echoed amongst all of us, that we really want to see you delve into this in greater detail, both in this paper and hopefully in a series of papers. And I do believe that this can and probably should be a series of papers. I also want to echo Anumeha's comments that the language and structure of the paper is very clear, and that is to be commended. Especially being relatively junior, that is something that a lot of junior scholars struggle with, is how to write in a way which conveys complex ideas in a non-complex way that doesn't obfuscate. And so a lot of people tend to pick overly complex sentence structures, paragraph structures, and paper structures, and hide behind that. And so I don't think that you've done any hiding. I think that we understand what you're saying. We may not agree with it necessarily, or want you to think about some issues, and I'll come to that. But I know what you're saying, and I think that that you're being very clear. I also think that you canvass a lot of, or you canvass case law that I was not aware of, and I think that a great number of people are not aware of. And you do empirical work, on the prevalence of gender terms across different statutory frameworks, which is super interesting and super helpful. I'm not sure that all of that, especially the empirical stuff, belongs in this paper, but I think that you are onto something, and I want to encourage that. So I have, I think, 5 big points that I want to kind of jump into, and then one relatively minor but still important thing that I think that you need to consider at the end. So the big point, and I think I foreshadowed this already, is that it's sometimes, let me just state it frankly. I think you need to decide what your paper is really about. So I think what I read and what I hear from your words is that you are really interested in the non-implementation of the NELSA judgment, especially in the area or on the train of property and inheritance law. And that non-implementation is happening either because the difficulty, or maybe even an impossibility, of doing it in a legal framework which is highly dependent on a gender binary, and is highly dependent on complex and perhaps impossible ways of proving kinship. So I don't know if that precisely is what your paper is about, but that is what I heard coming through across the different sections. And if I'm correct in sort of understanding what you're really concerned about in this paper. I think a lot of stuff needs to be cut, and there also needs to be a further drilling into the two core concerns concerning the gender binary and the difficulty of proving kinship. So you engage in a lot of criticism of the self-identification problems in the contemporary current Indian regime, but I don't think that that is your focus, and I don't think that that's where you're contributing the most here. I mean, there's been a lot of critique of the way that the 2019 Act has implemented or institutionalized self-identification, or not implemented or institutionalized self-identification. And I think you don't need to replicate that work. It may be important or necessary to mention it at some point, but you spend too much time on that, and I would encourage you to think about ways that you could trim back that analysis. As well, you engage in an international law discussion, and that seemed to me, again, not to be your core concern. Now, I still think that you can use it to maybe initially frame the importance of the issue and your paper, but I don't think it comes across as kind of strange in the way that you use it at the very end of the paper. So I would encourage you to either drop that or to put it in the introduction as a way to kind of grab the reader's attention and grab a wider or sort of a broader audience's attention. And I'll talk about audience in a second. I think some of the statutes and cases that you mentioned, they're super interesting. I mean, there's been super interesting legislative efforts in Uttar Pradesh, as you describe it. There's also this historical case or cases on transgender inheritance, which I have not read about. And, you know, that is just, those statutes and cases are mentioned, but they're not really gone into with a sufficient level of detail. Now, I mentioned sufficient level of detail, but I may be wrong here, and I think this is a lead into my second point. I think you really need to think about who your audience is in this paper, and there's lots of potential audiences. But the big question I had is this for an Indian legal audience or Indian scholarly audience, or is it for a broader audience? And if it is the latter, I think you need to do a lot more explanatory work on how inheritance works in India, and in particular, how inheritance works across India's different communities, religious communities, the personal law system in short, at the very outset. So particularly when I was reading on page 9, I thought that the discussion here about inheritance law, it seemed relatively like free floating, and I'm not sure who would instantly appreciate and understand all the terms, geographies, frameworks that you mention on this page. But if it's an international audience or a global audience, or just a non-Indian audience, I think that you need to do a lot more explanatory work. So again, I think it would be helpful for us to get a better grasp at the outset of the paper, after the introduction, how inheritance normally works for different populations in India. Okay, so my second major point is thinking about audience. Now, as to the argument, and I guess 3 different argument points I want to raise here and just sort of throw out there for you to think about. You seem to conflate the existence of a gender binary and the problem of having a gender binary in the law with the problem of assigned gender. And this is something that this is a kind of conflation that I see coming out on page 4 initially, but then it kind of echoes in later parts of the paper. And so I don't think that this is the same problem. It may be, there may be overlapping issues that come up with having a legally instantiated gender binary and a legally instantiated lack of gender choice or self-identification. But they're not the exact same issue. And I think you need to do kind of more conceptual work in teasing out precisely what you are concerned with here. So I think this is obvious probably to you, but it needs to be kind of grappled with more explicitly in the paper. Even if you can change your gender, even if there's a robust self-identification regime with respect to gender, it might still be problematic if you can only choose, two genders or choose from two genders. Conversely, you could have a multiplicity of genders, recognized within the legal system, but it could be a further problem that there's no possibility of changing between those gender categories. So again, sometimes, let me be more frank, oftentimes I'm just not clear whether it's the gender binary or the lack of potential movement in the gender terrain that you're precisely worried about. Another conceptual issue that I think you need to grapple with more is how documentation of kinship relates to the issue of sex discrimination. So again, this comes up on page 4, and then on page 15 you have a really nice statement that I want to kind of highlight, which I think is the crux of your a great number of your concerns. So you say on page 15, inheritance requires one to prove their identity, one's relation to the deceased person, and the residence of both parties, neither of which is possible without legal mandates to recognize transgender persons in identity documents. Binary classification of gender into male and female that does not recognize a third gender turns the transgender status into a legal non-entity. So it's this, kind of proving your identity and your kinship relation, which is posing a problem. But this is something that happens across a number of different legal areas, and is not strictly an issue with regards to transgender rights. So the relationship of a regime where it's difficult to prove your kinship, prove your relationship, prove your identity, and how that relates to sex discrimination per se, that wasn't immediately obvious to me. Now, the big conceptual thing that I think that you need to think through is whether this is really an issue of civil rights. So throughout the paper, you use the language of civil rights, and I wasn't convinced that that is really what is going on here, or it really is the best language. It may be an issue of justice, but civil rights has and that term, or at least the use of that term that I'm familiar with, has a genealogy which, often understands these kinds of rights as political rights, as rights that, you are claiming from the state, that because you're in a relationship of citizenship, in that state, or residence in the state, or whatever it may be. And these property issues, and particularly the intergenerational transfer of property, don't, to my mind, necessarily fit within that genealogy and fit within that rubric of civil rights. Now, they're material rights, they're welfare rights, but I'm not convinced that they're civil rights. There's another issue here too, in that it's not clear to me that this is an issue that pertains to ordinary individuals. Now, it very well may be, but I think that you need to do more work explaining why this is an issue of ordinary welfare rights, or ordinary human rights, or even if you want to stick with the language of civil rights, ordinary civil rights, right? The intergenerational transfer of wealth has a lot of class associations, a lot of class connotations, and it's not necessarily, the stuff of human rights, even though elite discussions, propertied, wealthy discussions of rights would certainly like to see inheritance rights so that children can inherit wealth of parents. But if there is no wealth to begin with, there's not much to be inherited. And so I think you need to do some work convincing us that this really is the kind of issue that your language's civil rights suggests it is. Two more things. So I think you know this, but and the language in this section came across as a little bit rushed, but that's understandable. It's towards the end. But I think your conclusion and recommendation section still needs a lot more work. So you seem to be kind of pulling in two different directions. So on the one hand, on page 23, you seem to say like, well, all this gender binary language and these different, Hindu and Muslim and other, statutory and legal frameworks in India, it just can't be reconciled with contemporary understandings of gender. So we need to like throw out the use of gender in inheritance law. On the other hand, you say on page 24, just one page later, that these legal frameworks need to incorporate a transgender legal status within the gendered way of doing inheritance. So I wasn't clear whether you want to get rid of gender, whether you want a gender blind system, or whether you want a kind of more inclusive system that recognizes a transgender identity. My last point is relatively minor, but it's something that I think that you need to pay attention to as you turn this into a final draft and maybe something that you're submitting to a journal. A lot of your citations are either not comprehensive enough in the sense that they're missing some important contributors to the discussion. So one person who I thought you really needed to mention at multiple points in the paper is Jessica Hinchey in her recent book on the colonial experience and colonial regulation and maybe even colonial genocide or attempted genocide of transgender people in India. So that was one person who I thought was missing. I think also Lawrence Preston's work needs to be mentioned. And then in a lot of the footnotes, I'll just mention two here, but on page 7, note 36, and page 15, note 87, you cite to either an author. On page 7, you cite to Deepika Jain. On page 15, you cite to a PUCL report, but it's not clear how those citations are supporting the point that you're trying to make above the line. So I think the footnoting and the citation needs to be made more precise. Tell us where exactly in that work this point is, and also if you're doing a kind of paraphrasing work, I think you need to explain that you're paraphrasing Jane's work or paraphrasing the PUCL report. So I'll just stop there with my comments, but overall, I do want to encourage you to continue work in this area. And I think you've got a very, very solid start. And I think that if you kind of plug away at this on the different points that me and Anumeha have raised over the next few months, and really sort of hone in on what your argument is for this paper, not only will you have an excellent paper on that topic, but you have a lot of material left over for another 2 or 3 papers easily that I can envision. So let me just stop there and again, thank the organizers for inviting me into this discussion. And Tushar and Karan for writing the paper.
Thank you, Jeff. That was quite a lot to be taken even for our participants and me as an early scholar. And I could not agree with Jeff more on points 1, 2, and 3. I'll take 5 minutes to share my comments on the paper. As a reader, I really enjoyed this as an early draft, but I think the topic is so unexplored that it has a good potential of being carved out into a wonderful paper. As mentioned by Jeff, point number 1, his first comment that a lot of stuff has to be cut. even I, as a reader, believe that many portions in the text are there which should have been in the footnote section. Also, I think we are on the same page on point number 3, what Anumeha mentions, and when she quotes that how these discriminatory laws affect transgenders, they also affect women. So that point, and I think at 2 other occasions in the paper, there are sentences which would confuse the reader that why is this point mentioned? So the topic is nice, but this thread is pulled in many directions because there are many things that are that make the paper informative, but then that divulge the reader sometimes from the main stress point, and that makes, I think, your central claim under stress. Also, why this paper and why this topic? These are 2 answers that should come in either in the abstract or in the introduction, which I, as a reader, thought that they were underconfidently dealt. So I think I related to this paper a lot while I read this, because this is how I wrote my first paper. That was a lot of information in the paper, but then I kept on losing the track of the central argument. So I can see, as a reader, I can see that research is done. There are some wonderful case laws. There are some wonderful findings, like one finding on page number 8, one observation that how for identification process, transgender persons have to appear before psychologists and administrators, and also at one of the point at page number 15, that how their identification can be rechecked based on the notion that misconception that welfare measures will be misused. So I think these 2 arguments on page number 8 and 15 are wonderful observations by the authors, which they have missed to dealt with much of force. So I think there are some observations which are wonderful, but as a reader, they go unnoticed by the eyes because of lack of vehemence at some portions. And I think that's a chronic problem with early scholars, because even I, as a scholar, am learning how to write wonderful papers. So for example, the point 3.2.1 documentation, which is there on page number 15, where Karan and Tushar mention about the misconception, how the mandate certification is also checked. This could be related to, for instance, this could be related to how social stigma-driven entrenched biases are there, and that affect this double checking, because in other laws there's no law that cannot be misused by human society, but we do not focus on that. But as a conventional society, we focus on that, on rechecking the gender identity of transgender people. So how that is double discrimination, maybe this could, or any other thing to prove this point, could have come here. There are a few portions which I thought could be were wonderful, like on page number 16, the second line. This is because of non-uniform acceptance of third gender in state documents. This is a wonderful point. I think that should also be dealt with in detail. That would really make the paper interesting. Third point, second comment that Jeff mentions about who your audience is really a very pertinent question, because the paper is titled Inheritance Rights of Transgender Peoples in India. Although in the latter part, we see that you mentioned about the inheritance laws of other countries, you also draw a parallel of neighboring countries which are socially or politically similar to that of India. So that argument, instead of putting that as a subheading, this is totally a suggestion. So instead of putting it as a subheading, if you could mention those portions where you are mentioning that Indian laws are discriminatory and problematic, and what is there in other neighboring jurisdictions that we could borrow or adopt. So that's just a suggestion, but I think that would give impetus to what your central argument is. I'll wrap up there. I think these other comments, I have one or two. I'll come to that after some time. Okay, Karan and Tushar, do you want to respond to any of the comments that Anumeha and Jeff have made?
Yeah, if we have the time, I suppose we could address you. Okay, so first, of course, thanks to all the organizers for having us. Thanks to Anumeha and Jeff for those excellent comments. Some of them are high praise, and we see how deserving, but nonetheless. One point I want to address at the offset, which Jeff made, was at giving credence to authors who worked on this topic more. That flows into one thing I want to mention, is that there are some edits in the paper which were made recently enough, which I'm hoping will address some of these comments. One of the edits is to include authors. If I remember correctly, we've included Jessica Hinchy's work, and the other, of course, we've included cited, which was technically there, but we hadn't cited, was Jeff's own work for the Pakistan legislation, 2018 legislation. And so it's high praise getting his comments. The other main edit that we made to the paper since we shared the previous draft is that we understand that I think quite some comments touch upon it, is that we mentioned certain information, but it's difficult to find the link between those and any consequences. The way we've dealt with this issue is to pick upon the situation mentioned in the introduction, which is Ajay Mafatlal's case in 2005. Just a minor, just to call back to it. Then Aparna Mafatlal, now identified as Ajay Mafatlal, his brother accused him of doing so for inheritance. What we've done is we've adapted the situation slightly more. We've added some information and made a hypothetical situation, which then runs through the course of the paper. So we show, for example, in the Indian Succession Act, how does the difference between Section 8 and Section 15, having different provisions for male and female succession, affect in that particular hypothetical situation, right? And the idea is that this also addresses another comment, which is that just summing up the count in that table of gender provisions might not be enough, because as Jeff mentioned, gender provisions might not necessarily affect inheritance rights of transgender persons. So we try to show wherever that might be the case. And we try to draw a difference between assigned gender and its relation with binary law, which is one comment I will make. I'll try to address the rest of the comments a little quickly in the order that I've noted them down. One comment from Anumeha is the difference between codified and uncodified law. This is well taken. The Muslim personal law, as she mentioned, is largely uncodified in India, and that's the reason why it doesn't have the discussion it merits, as opposed to the Indian Succession Act and the Hindu Succession Act. And I get the interpretation that someone could have seeing this difference between the laws. The reason that has happened is because it's uncodified, and what we identify as a challenge comes from the decision in NALSA saying that there are gendered provisions. De facto, there can't be provisions in an uncodified law, but that seems like a hyper-technical argument, and we'll try to incorporate the uncodified portions of it as well we can. On the sentence which garnered some attention, which is on women's rights, on these challenges affecting rights of women and on other gender minorities, the idea, it draws to Jeff's comment on giving credence to authors, and the literature we cite, and we'll be more clear about this, is on women's rights, and that's why we wanted to make sure that these arguments that we've gotten them from are more on women's rights, and previous work, both of the Law Commission and independent authors focuses on that. What came to my mind during comments was maybe perhaps you can move this to footnotes, which will also address some of the fact that we're explaining footnotes better. On recommendations, I take it wholeheartedly that there are problems with, I'll come to Jeff's comments on recommendations in a second, but on Anumeha's comments on just editing the text of the law may not be enough. And we've seen in the past that the 2005 Act did not have the consequences it intended. I agree. One is obviously the challenge between Section 8 and 15, which it just failed to address, and the other is the Section 6 challenge that Anumeha mentioned. The reason and we'll make this more clear, is we've tried to temper the recommendations to our research. And though there is no doubt in my mind that there are 100 other changes needed in the Indian landscape, the recommendations are more based on what we find. And that is why we've only limited it to what changes are needed in the legislation. There are probably changes needed in let's call it delegated legislation. There are probably changes needed in the structure of bodies constituted by the Transgender Person 2019 Act. Just the fact that we haven't, and of course there are societal recommendations which are important. It's just that we've tried to focus on legislation because that's our work, and given these are two heterosexual male persons, we don't want to overshoot our welcome and give recommendations on things we're not more aware about. But what we can do definitely is to say that these things exist and we need more work on different aspects which might address these parts. If I missed any comments, Anumeha, I will contact you separately, and I would love to continue this discussion. These are excellent comments. I'll quickly move on to Jeff's comments, which is there are two things I take importantly, which is a discussion on the 2019 Act and the international law section is perhaps not as warranted as other parts of the paper. On the 2019 Act, we'll have a discussion. Tushar and I and team at NIPSP can have a discussion after this paper. It at least warrants a discussion amongst us on what we want to do. On the other hand, on the international law section, the reason that exists is to talk about the reforms and conclusion portion and to temper those suggestions in what has been happening across the world. Perhaps it can move to those sections itself, but we'll try to keep that knowledge base as much as possible, because we don't want to make suggestions which are which come out of our own mind, right? This brings lastly, I'll try to address all the other comments quickly. This brings me to the next point, which is more detail is needed in a lot of things, and that's absolutely taken, right? This also goes into who is this paper targeted for, whether it's an Indian audience or an international audience. It's targeted as a working paper for an Indian audience. We're trying to see what we can get out of it. In the longer run, it's perhaps targeted at an international audience. And one of the main things we wanted to take away from this discussion today is where do we want more explanation? Because at least personally, I know a problem that happens is that I tend to assume knowledge on part of the readers, and that makes a lot of jumps. And I absolutely understand that there are portions which assume a lot of understanding. I won't even call it understanding, but just front of the mind knowledge. So people can know it, but it might not come to their mind when they're reading this. And I've taken particular note on where we want to make more changes. The case law explanation is, of course, one of them, and we can do that. Civil rights as a genealogy will change, right? That's an excellent comment. That just happens when you're an Indian author. Now that you mention it, I recall a lot of international literature on meaning of civil rights and how that's not really what an Indian audience might understand. At least I and the team that we discussed it might understand. But given that we might position this in the future for an international audience, there's no justification for my end. We'll see how to change that phrase. But on the other hand, just to draw from that comment on whether this is even important enough as a civil right or a welfare right, we have literature, and again, it's excellent that all of these comments sort of go together, because one literature not one, important literature we have is how in India, most wealth, whatever that may be, whether substantive or not, is transferred by inheritance. And so it could be a measly sum, but that's still inheritance for a person. And so this, again, goes to the fact that we need to, one, explain our footnotes better, and second, just explain literature better, right? So that argument will come. Yeah, the comment I have left, and please add to any of these if we have the time, is whether we want gender neutral or gender inclusive recommendations. The idea is, and again, this is something we'll elaborate on more, I've taken particular note that we need to do this, is that we want gender neutral provisions. But if that cannot happen, and I think this caveat is done with one word, which is else. Do this, else do this, which is not enough. But what we want is gender neutral provisions. And if that cannot happen, have gender inclusive provisions. This is based on the Pakistan legislation, which I feel is a good, I mean, I don't know how much trouble I get into this for, but it's a good baseline to take from. Yeah, I suppose that's my notes on the comments. If I missed any, I'll be more than happy to address them. And more than that, I'm more than happy to take any other comments on the topic because we need whatever we can get. Thank you. Tushar, if you have something to add.
Thank
Yeah,
you.
there was yeah, there was one comment on from Jeff, I think, on whether the gender binary in law or the lack of movement is what we are focused on. And he's right that we conflate these two issues, but the way that we have it in our head is that these two are pretty overlapping issues for inheritance either way. So I think that actually explicitly saying that these are two different issues and explaining that these are overlapping in the case of inheritance is something that would help understand the paper better. And the conceptual arguments that Anumeha also mentioned were quite nice. We should detail that aspect. And I think Karan covered most of my notes also. So, but yeah, point well taken. Thank you.
Okay, thank you, Karan and Tushar. I'll hurriedly mention one point that I forgot to mention, and then we'll have the floor open. So it is on page number 17, when the authors quote section 5 of the Hindu Marriage Act that provides a marriage in relation between a bride and a bridegroom. Now, they leave the section here and mention that whether these terms include transgender persons is left to the reader's sense of gender. I think leaving it here creates a confusion and tells us that the drafters of Hindu Marriage Act were progressive enough to consciously pick up on having the words bride and bridegroom there, which is not the case. And I say that it's not the case because of the year in which it was drafted, because of the judgments that were passed during by the Supreme Court and High Courts during those years and after that. Also because of the Special Marriage Act, which came quite later and it used the phrases male and female. Also because of the fact that in Indian society, the marriage between male and a female and male, the female has to be of 18 years of age and 21. So having bride as 18, it clearly connotes that that is referring a female and not, it's not a purposely used term to make it gender neutral or to be inclusive of transgenders. So that's I think one point where it could be improvised, or maybe one or two sentences could be added to clear off the confusion. Okay, so very, very well taken response from Karan and Tushar, the authors of today's paper. Now we will welcome comments from our participants. The floor is open. So participants may share their comments, their suggestions for the Tushar and Karan, for the authors of the paper, to improvise upon the paper. I can see few hands risen. Professor Dinesha Samratne, can we go with you?
Thanks, Swati. Thanks, Tushar and Karan, for giving us the opportunity to read your paper, and also Anumeha and Jeff for those fantastic comments. I think both of them articulated very well some of the questions that I was marking for myself when I was reading through this paper in preparation for today's discussion. So I will just associate myself with their comments and add a few other comments which I would suggest you think about when you revise your paper further. So my overall question was on the theoretical approach that underpins the claims that you make in the argument. There is this idea of equality, but I think as both Jeff and Anumeha mentioned, it would help us as the reader to know your theoretical commitment so that we could follow along and evaluate your interpretation and your claim for ourselves as well. So taken as a whole in the paper, what I felt was I was not being accounted for as a reader in your paper. I felt that I needed to sort of find my way through the paper. So if you could remember, I mean, I had that audience question as well, and you've sort of dealt with that already. But in addition to thinking more broadly about your audience, but also think about the fact that you are trying to take someone else along with you and to sort of get them to think alongside of you as well. I think that will help you to clarify some of the current dilemmas in the paper. So in that spirit, I also wanted to sort of push you a bit further on what seem to be the methods. You state up front certain number of cases, but actually what you're doing, so I was wondering whether this was going to be a quantitative study or a qualitative study, but it is actually, from what I could understand, a qualitative assessment and a qualitative claim. So maybe if you could signpost that, some of these comments would only require that you change a few things or even footnote and further qualify what you're saying. So some clarity on why you're saying what you're saying and how you're saying it at the beginning of the paper would definitely help the reader. The other question I had was about the legal sources you use. And as was already mentioned, it will be more helpful to have the international law and the comparative examples dealt with upfront, if that's what you want to do in the next version of your paper. But alongside of that, I would like to, I was curious about the implications of the constitutional recognition of the transgender identity. I felt like you hadn't explored the analytical purchase of the development, particularly in understanding the response of the central government, the state level governments, the written law, the regulations, and then also customary law. So if we could have that thread running a little bit more consistently, that would be helpful as well. And finally, here I'm sort of throwing across a question to you for you to consider. You can take it or leave it really. If this paper is to be an academic intervention, I wonder whether you need to consider recommendations at all, because perhaps that may come in a different format for a different audience in a different way. Whereas this piece could be the piece that lays the theoretical grounding on which you then make your recommendations. Then you're free to be more normative and theoretical in your analysis here. And that would then allow you to develop your research agenda further. As was mentioned already, there are so many other dimensions to which you can carry this argument, whether it's to do with the recognition of women's rights, but also to critique the law as a colonial instrument, which is at odds with the society which it is regulating at the moment. So thank you very much.
Thank you, Professor Dinesha. So Karan and Tushar, would you like to respond to that now, or do we take Professor T.T. Arvind's comments as well, and then you will respond? Karan, what would you like to do?
Yeah, I think if there are more comments, maybe you can take them now and we can address all of them.
Yes, yes. Okay.
But thank you nonetheless.
Professor T.T. Arvind, I see you have a comment to make. Yes.
Yes. So first, like everyone else has said, I really enjoyed reading this paper. On a personal note, I was quite pleased that you'd written it in LaTeX. I'm a user of LaTeX myself, and it's always nice to see legal scholars using it. I think I agree with the point a lot of others have made, which is that this is actually setting out a program of research rather than just being one paper. So a lot of the comments I'm going to make are addressed to the broader program of research and not just specifically on this paper. I think I want to echo what others have said. You need to do just that bit more to bring a generalist, non-specialist reader along with you. You can't do a paper of this just speaking to researchers working on trans rights, because A, the community of researchers doing that in South Asia is very small. And B, if you want to get momentum, you've got to get constitutional scholars, you've got to get family law scholars and others seeing that this is something that matters to their fields. And to do that, that's why you need to do the bit more to bring them along with you. That's how you get momentum behind the framework you're trying to bring out, and that's how you get influence over the cognate fields of law that you need to work in. I very much liked your use of qualitative research. I have a couple of comments to make, not criticism, but just ways in which I think you could take it further or add more nuance to it. I think you could do more to build on legal knowledge and legal scholarship in setting up your qualitative framework. From a legal perspective, there's a distinction between a mere gendering of language and an actual gendering of rights. I think Table 1 doesn't really bring that out. Some of your discussion speaks to it. So, for example, the fact that Indian law being the colonial artifact and having the Victorian base in the way it uses English, always uses he. That's a gendering of language. It doesn't necessarily imply a gendering of rights. Whereas when it says a daughter can do this, that is a gendering of rights. When a particular right is specifically related to a son or a daughter, that's a gendering of the right and not just of the language. I think your framework is able to make the distinction. You haven't made it. I think if you make it, it'll add a lot more nuance and power to your analysis. Secondly, I think there you also need to make a distinction between issues that can be addressed by treating persons with a transgender identity as members of the self-perceived gender identity, and issues that can't be addressed without challenging the gender binary in law. Some of the points you make can be dealt with in the first way, others require the gender binary in law itself to be challenged, because it's not just the use, it's not just the fact that it says women and not women and trans women, but the fact that you simply can't deal with trans issues within a male-female binary. I think making that distinction again will help you give a much stronger diagnosis of the legal problems. I also wonder, and I think this picture picks up on something Dinesh said, I also wonder if you could do more with the constitutional framework. I mean, you talk about the judgment, but then the fact that this is actually a constitutional matter more or less disappears from your analysis. If you bring the Constitution in to some of the later analysis, I think that again might help add more nuance to it. Customary laws, I think we have positive statutory law and we have customary law. Customary law poses issues largely because of religious sensitivities. The courts are going to be a lot more wary of saying this is how Sharia should be interpreted, or this is how Mitakshara should be interpreted, than they are when it comes to saying this is how the Succession Act should be interpreted. I don't know how you deal with that, but I think at least acknowledging that would perhaps help justify why you're not dealing with customary laws in the same depth as you're dealing with positive law. Two other points, I think, and this may not be for this paper, but probably for future work. There were places where I felt you were eluding differences that have policy significance. I'm thinking of your discussion on page 19. So family law, recognition of transgender people in family law raises very, very different issues from whether a trans woman should be treated on par with a woman for the purpose of affirmative action law. But on page 19, you sort of seem to equate the two, saying the Madras High Court agreed to do it in family law, the Calcutta High Court refused to do it in affirmative action, but there are very, very different policy issues here. I mean, there's a public interest litigation pending in the Madras High Court right now, which is seeking to get specific affirmative action and reservation for transgender persons. So, when it comes to that, there may well be a case for treating them separately. I'm not saying there is, I'm just saying it's a different policy issue. And I think it would be useful to see that feeding through. There were also bits where, I mean, I don't know how you deal with this, but I think language becomes such a huge issue in different languages in India. I think on page 15, you talk about a third gender. This actually is hugely controversial in the Tamil language. In 2019, the government of Tamil Nadu moved away from using the Tamil terms Tirunambi and Tirunangai, which were used for transgender men and transgender women, to using a different term, third gender. This was hugely controversial and perceived as deeply offensive by the transgender community. So I think when you talk about things like recognizing a third gender, the nuances that creates in local languages, I think, needs to perhaps be considered a bit more. And that also leads to the law politics, by where you hinted this in some places, but huge issue we have is that you can have great laws, but a lot depends on which political party is in power. In Tamil Nadu, this has been a huge problem. When one party goes out of power and the next comes in, the entire approach gets turned on its head. So for example, now, after a recent election and a change of government, the new government has just happily conceded that it's going to give COVID relief to transgender people who don't have a gender recognition certificate just based on their own self-identity. That would have been inconceivable under the previous government. And I think part of the argument you perhaps need to make is that is problematic when so much depends on political will. We need to have a way of making these enforceable rights. I think that's in a sense what you were trying to get at by treating it as a civil rights issue, but perhaps treating it as an issue of legal entitlement rather than political will is perhaps a better way of framing it. That's it for me.
Okay, thank you, Professor Arvind. I think that was a very, very pertinent point he mentioned about the distinction between gendered language and gendered law. Can we take two more comments? I can see two raised hands, Saptarishi and Akshats. Can we take those two comments and then directly move to responses from Karan and Tushar? Okay.
Yeah, sounds good.
Okay, thank you. So Saptarishi, can you, yes, Saptarishi.
Yeah. Hi, it's Saptarshi. Thank you so much for the paper. I have three comments. The first one is a theme that runs through the paper, but which sort of remains largely unsaid. So the title of the paper is Inheritance Rights, but in course of the paper, you also talk about marriage and adoption. And that brings up an unsaid aspect of Indian family law, that despite having different statutes, all the issues are interconnected. And you cannot really talk about inheritance without, so if you just amend the inheritance laws, then some people benefit and some people lose out. So if I'm a trans person, I will, and if you just amend the inheritance laws, then I will be able to inherit from my parents, or my children will be able to inherit from me, but then I won't be able to inherit from my spouse. Maybe sort of bring out that aspect. You could, and then you could acknowledge that in, I mean, I don't know how you're going to then acknowledge that aspect in the title of your paper. So that's one. The second is, like the others said, making the women's rights issue more central to your analysis. I mean, why do we have a gender binary in the laws, and what purpose does it serve now? Or what are the remaining sort of, what's the remaining relevance of a gender binarized structure after the 2005 amendment, which has sort of pretty much put men and women on the same at the same sort of level as far as the Hindu Succession Act is concerned. But then that also, I mean, it does not solve all your problems, because even a women's rights angle in Hindu Succession Act or the statutory inheritance laws is compatible with other laws where you retain that gender binary. So for example, you could do away with gender in succession laws and yet retain gender in marriage laws and adoption laws and guardianship laws, right? Because legislators are, so for example, for the last couple of years, we have been talking about inheritance rights of trans people, and there is a level of acceptance, or that issue has some sort of degree of legitimacy, but lawmakers tend to be sort of, you know, unfriendly to the issue of same-sex marriage or same-sex adoption and those issues. So the women's rights angle both helps you and does not, and so maybe you could sort of explore the tensions as to where it helps you and where it does not, and how it sort of helps you in your argument. My last set of comments are about the marriage portion. So on page 16, you say that courts have held that marriage is a fundamental rights guaranteed to all persons in India, and then you cite Lata Singh. That's actually incorrect. What courts have held, and not just in Lata Singh, but in subsequent marriage cases, that individuals have a right to access marriage where marriage is available to everyone else. But there is no fundamental right to marriage itself, right? So in the sense, if tomorrow the legislature did away with all the marriage statutes, then that argument does not work anymore, because the state is no longer providing you that right, that facility, that service, right? So in all these cases, all these honor crimes cases, Lata Singh is also an honor crime case, the emphasis is on access to a legal right which the state guarantees. So non-state entities cannot sort of restrict that. The other is something that Swati mentioned in her comments about your interpretation of Section 5. So HMA is actually pretty clear. So despite using seemingly gender neutral language, if you read the statute as a whole, it becomes very clear that bride and groom are references to a male party and a female party. Or even when the statute uses the term parties, so this becomes clear when you pay really close attention to the definition clause who can marry whom and prohibited relationships and so on and so forth. So that is as far as Section 5 is concerned. But I was also wondering why you feel there's another point on page 11 where you say, for example, the Act is silent on whether a transgender person who identifies as a male would be entitled to inheritance under Section 8. I think that would require some explanation as to why you think so, because in light of the Madras High Court's judgment in Arun Kumar versus whatever marriage registrar, women include trans women, and so one would think that men would include trans men for marriage purpose, and if that's the interpretation that courts have adopted and marriage registrars have adopted for one family law, then there is no reason why they wouldn't adopt the same interpretation for another family law. So to my mind, a trans man will be able to claim inheritance under Section 8. So if you think that's not the case, then probably you'd have to sort of make that argument rather than just make a statement that that's not possible. All right, I'll stop there. Thank you.
Okay, thank you, Saptarshi. Those were some nuanced comments. I'm so sorry that I mispronounced your name. Sorry for that. Can we have Akshat Agarwal's comments?
Yeah, hi. Can you hear me? Yeah. Yeah, thanks. Firstly, it's a great paper. I think it's really good that people are writing about doctrinal issues in transgender family laws. It was really good to see the paper and to read it. My comments were again specific comments, which are similar to what Saptarshi was also saying. So first was just with regard to your discussion of the Transgender Rights Act. Now you say that medical examination is still essential, but I don't think that's a requirement anymore after the rules have come in. So you would want to refer to the Act as well as the new set of rules that have come in, which explicitly say that no medical examination is required. And as far as I understand, transgender people are getting certificates of recognition without any medical pre-evaluation now, merely on the basis of a self-declaration and in an affidavit. So that is a legal thing. It's also one of your main recommendations in the end. But I don't think that's a problem in the law anymore. It may be a problem in implementation or the fact that officials may not be sensitized, but it's not a problem in the language of the law. because these are the latest rules that have come in last year. So you should just go through those rules to sort of recheck your parts from the Transgender Rights Act and your discussion of it. Secondly, again, a very technical point, in your bits on the 7th schedule, you refer to the transfer of property entry, but another entry to refer to would be the family law entry, which is inheritance, marriage, etc. Because again, your paper is linked more to family law, I think, than transfer of property. And that would be the sort of relevant entry to sort of link all of your discussion to. The other parts were just about and again, the point which Saptarishi was also raising about, how you discuss these cases. Because the fact is that the Madras High Court has read trans women as women, and that would mean that for purposes of family law, a transgender person who identifies as a trans man or a trans woman can be considered that gender for that particular law. And you sort of argue that it might need some theoretical weaving because courts have not given this decision in the context of inheritance, but I wasn't clear why you say that and what theoretical weaving do you refer to, because as in from just a understanding of interpretation, and that's probably, it also happens because you discuss cases and legislation separately, but even a better understanding would come if you discuss the cases and legislation together, because the cases show the current position of the law rather than just the legislation. So I thought, as in, you might want to explore that further. And again, I think Professor Arvind also said that, as in different laws may have different cases, may have different policies in question, and therefore they may have different approaches to whether they want to identify transgender persons as women or men. Because, I mean, all transgender persons usually do want to identify as in, well, not everybody identifies within the binary, but a lot of people do identify within the binary. And that's a problem with the Trans Act, that it does not let transgender people become trans man or trans woman, right? It just gives you a certificate of transgender. But once you get a certificate of transgender, in a lot of case law now, courts are just recognizing a transgender person who self-identifies as a trans woman as a woman. And that's happening in case law in Karnataka, in other high courts as well. So that's something you may want to sort of consider. The last point was about neutrality. And again, you seem to sort of hint towards neutrality in family law, which again, I think is a major recommendation to give and something to think about a lot, because oftentimes, as in family law explicitly does not have neutrality because it wants to identify power relations between genders, or it acknowledges the fact that there is power between male and females, and therefore you need specific provisions for certain genders. And the fact is that if you do away with that difference of gender, it might lead to a lot of consequences for, say, women or other parts of family law. So I think it would be good to engage with some literature on neutrality itself. I mean, there's a lot of debate on neutrality in criminal law. I don't know if there is debate on neutrality in family law, but it'd be good to explore that and see what people have said about it before giving a recommendation which says that, you must move towards neutrality, because that might have a lot of consequences in the way in which family laws operate. And I think it's also because different personal laws have different histories, right? So there's a reason why the Hindu law has developed a certain way and has incrementally recognized the rights of women, right? Going back to the early property legislation before independence, to the codification to 2006, right? Similarly, Muslim personal law has a history of how it has recognized rights for women. So I don't know what it would mean to suddenly say that this should be neutral. And, how would you sort of solve for those problems? So again, something to think about. Yeah, that's it. Thank you.
Okay, thank you, Akshat. So, Karan, would you like to respond to those comments?
I tried to take these one by one, but again, I suppose because these are similar challenges which everyone is reading into the paper, I might overlap, and I apologize for that. The major comment that first came is explain more and explain how the Constitution impacts, which we got from two discussants, which is absolutely taken. Again, as I mentioned earlier, we definitely need to explore, right? There's no argument in that. On the Constitution, that's an excellent suggestion, because apart from just taking care of the audience, which is a point taken, it sort of comes with experience that we need to sell this paper as well. And the fact that constitutional scholars might be better positioned as an audience for this paper it's something we hadn't thought about, but it's now that you mention it, I can't not think about it, right? So we'll definitely take that on. Right. There's what this also does, what the last half an hour or so of discussion has also done, is just give me 1,000 ideas on what new papers we could have. one of which is on customary law, which is, though I was earlier thinking of it as maybe we just weave it into the paper, which is the Muslim law section. Maybe now that I think about it, maybe it's as a separate discussion to have, given how that's not really a gendered section provision, that's still, it is, however, regardless of gendered law problem. Gendered or not, I mean, I'm not an expert in that, but it might have separate challenges which can be dealt with separately. Professor Arvind, I lost you for a second when you were talking on about page 19 and the difference in courts and policy implications. So I'm just assuming what you said with what little I can hear. If I've heard you incorrectly, please correct me. Right? The comment I got, the little I could hear of it, was that the problems that courts have addressed are independent problems and can have separate policy implications, and that should be addressed. That's absolutely correct. Again, of 1,000 ideas, as I mentioned, which come off of this paper, maybe that's a separate tack to take. And if we do that, I mean, first, that's an idea to anyone in this call. We'll be happy to partner if anyone wants to work on that. But whenever that work ever happens, we'll be standing on the shoulders of giants, because I do feel like the impact of courts and policies is a separate literature field itself. And even within the rights of transgender persons for inheritance rights, that feels like something that feels like it deserves more merit than a discussion in a subsection. But we will write how that is an important position for people to take. On local language context, this is why we need expertise. We have no idea about this, right? And we'll read more on how local languages can impact any of the discussion that we've had. That's the comments I have from the first two discussions. If I missed something, then please feel free to jump in. Subtraction, your comments on a lot of interplay between different aspects of family law, that's correct, right? So one of the things we've edited since this version was circulated is try to justify why any of these challenges matter and why trans persons not being able to marry is a problem of inheritance rights as well. So we've tried to position that as much as possible. Hopefully it's enough, but we will take another look at it and see whether we've done justice to it. On the other hand, on what you mentioned, and I think Akshat alluded to this as well, is that several legislations are made for the protection of certain gender minorities, and just having a gender neutral provision might not be a good idea there. So that's absolutely correct. From what I recall in the paper, we've tried to write that after our recommendations, is that we need individual study across legislations, and we've given example how some legislation is meant to protect women's rights, and just making them gender neutral might not be a good idea. So we are mindful of this challenge to our recommendations. But what's important is that if the readers aren't able to gauge that from, I think that's about a paragraph, if I remember correctly, then we'll explain more about it. On Lata Singh and whether there's a fundamental right to marry, I'm not going to argue case law. Maybe we're wrong, and just re-look at Lata Singh and where we stand with that, right? Akshat, it's nice to hear from you on the rules and whether medical certification is required or not. I do remember reading the rules. I don't remember what they were, but I do remember taking a call that medical certification is something we need in the paper. So either I read them incorrectly, or you and I are reading something differently. Maybe there's an interpretation challenge. I can find is to cite parts of this more clearly and just elaborate on what's happening. I think those are all the comments. The other one I have is 7th Schedule family law. That just interplays into the constitutional selling of this paper, which once we start addressing the constitutional aspects of this, so from what I recall, we've just mentioned that you don't have 15 and 16 discrimination anymore, which is an ALSA decision. Once we start selling that more, I suppose the 7th Schedule family law aspect automatically will come in there. That's about it, or at least what I got. Again, if I miss something, please jump in.
Can I make a brief comment?
Okay, sure.
Okay. So in case of family law, you do not encounter the resistance to neutrality as much as you do in criminal law. because in the criminal law context, you have a victim oppressor kind of situation. In family law, you don't. It's more like an interrelationship and what you owe to each other, that kind of a situation. So the kind of so power hierarchy might be a genuine concern in the criminal law context. So there might be a reason to oppose gender neutrality in the criminal law context, but not in the family law context so much. So that the area itself neutralizes that argument.
Yeah.
Okay, thank you, Saptarshi. Thank you, Karan, for your wonderful response. I think I have to thank Karan and Tushar for their wonderful topic that they've chosen, and it's so unexplored that it created a lot of provocative discussion today at our workshop. I would thank Jeff Redding and Anumeha Mishra for their enriching comments. Those were very engaging. I personally learned a lot from reading the excellent paper and from the comments and the discussion that took place today in the workshop. I think with that, we do not have any further comments from our participants. With that, we would wrap up today's session. Thank you, everyone. Thank you, participants, for wonderful discussion today. Thank you.
Thank you very much.
Thank you for having us.
Thank you.
Thank you.
Thank you.